Hello students, topic for today's lecture is rule against bias. What is the rule against bias? So let's start with the doctrine of bias, nemo judex in causa sua. It is also known as the rule against bias. That means that nobody should be a judge in his cause. This principle has been established to ensure that the judiciary is impartial and free from the bias. According to Clarence Thomas, the duty of the judge is to figure out what the law says and not what he wants to say. Human nature involves emotion, and where there lays any interest, it is difficult to decide on one's interest, which leads to partiality and destroys the very idea of justice. A person can apply his mind effectively when he follows the path of impartiality. Now we'll discuss about the types of bias. First is personal bias. Any relationship arising between the adjudicating authority and the parties can lead to personal bias. The adjudicating authority might be a friend, relative, or might have any professional relations. Any personal relation might give rise to enmity against one party and favoritism to the other party. In the case law, being class state versus a workman, the inquiry conducted by a manager was considered to be vitiate as he acted as a judge in his own cause. In this case, the manager was accused of beating the workman, and the inquiry for the said allegation was conducted by the manager himself, which is against the principles of the natural justice. Now we'll deal about the pecuniary bias. When the adjudicating authority has any monetary or financial interest in the dispute, pecuniary bias rises. Any kind of pecuniary interest in the dispute will invalidate the proceedings and disqualify the person acting as a judge. In the case law G.J. Boy versus Collector in the year 1967 SC 1096, the bench was reconstituted when it was found that one of the members of the bench had a pecuniary interest where he was a member of the cooperative society for which the land was being acquired. Then comes in case Times versus Grand Junction Canal, the House of the Lords held that the Lord Chancellor failed to mention his interest in the respondent's company, and that was sufficient to invalidate the decision given by the Lord Chancellor on the ground of the pecuniary bias. Then comes the subject matter bias. Subject matter bias means the issue in the question. This type of situation arises where the adjudicating authority is directly or indirectly has any interest in the subject matter of the dispute. In the case of Gullam Nageshwara Rao versus APSRTC, the Apex Court held that the decision of the uploading and the upholding of the scheme of nationalization of motor transport by the government secretary to be invalid due to his interest in the subject matter, as he was the one who has initiated the process of nationalization. Now, uh, the principle of natural justice has occupied a crucial role in the study of the administrative law. They constitute the essence of the justice. The doctrine stands as a synonym for the fairness in the concept of justice. The rule against bias and the hearing rule constitute the two pillars of natural justice. The principles of natural justice not only secure justice but, more importantly, prevent miscarriage of justice. The application of the principles might differ, but justice should be administered in its true spirit. The objective of the doctrine of bias is to ensure public confidence in the administration of law. The court has to consider whether a prudent person, having considered all the facts, would reasonably apprehend that the judge would not act partially. The essence of the rule lies in providing a decision that is free from bias. Any biased decision creates insecurity amongst the people, and in a democratic country governed by the rule of law, adherence to the principles of natural justice is fundamental. If the contempt of law is not supplemented by the rules of justice, justice will be forgotten. It is justice that keeps awake when all are asleep. I think the topic of must be clear to you. Thank you.